This is a debrief of Task 5 from AAT's first sample assessment for credit and debt management. So Task 5 is about the techniques available to collect debts. So in Part A, it tells us that AB Building Supplies Limited has supplied goods on credit terms to a self-employed builder, but the debt of $6,800 remains unpaid despite a statutory demand for payment. Now there's a number in the text there. We need to appreciate that the number is there for a reason. So hopefully you'll remember from your studies that if we're owed at least £5,000, a statutory demand can be issued for payment of the amount within a certain period of time. Now, once the person's received the statutory demand, they have 21 days either to pay the debt or reach some sort of agreement with us to settle how much they owe. Normally, we'd make this demand within 4 months of the debt, but if it's older than 4 months, then you can go to the court and explain why there's a delay. But normally, if this debt is more than 6 years old, then we can't use this statutory demand tool. So we've done the statutory demand, so what can we do next then? So the first suggestion is the attachment of an earnings order. Well, what would happen here is that we would ask for the employer of the person who owes us money to deduct how much they owe us from their pay, not necessarily all in one go. It could be a weekly or a monthly deduction, and then that would be paid over to us. But that's not going to be appropriate in this case, is it? Because the person who owes us money is a self-employed builder. They're not an employee, so we can't ask the employer to deduct anything from their wages. So what about the next one then, a petition for bankruptcy? So in this case, we're going to ask the court to ask for this person to be declared bankrupt. So if that person who owes us money, if they pay any money to any other suppliers, or if they sell any of their property, then those transactions are void. So they're basically not allowed to pay anybody else. If there are any other legal proceedings relating to that customer, then they're all suspended. And then an interim receiver is going to be appointed to protect all the property, because we want to make sure that none of it's disposed of before we can decide on how we're going to allocate that to everybody. So yeah, that could be a possible solution in this case. In a winding up order, we can ask the courts to have a company liquidated, but in this case, this is a self-employed builder, so there is no company to liquidate, so that wouldn't apply. And then the fourth option is to appoint an insolvency practitioner, but for AB Building Supplies, they can't do that on behalf of the self-employed builder. So perhaps the builder could do that for themselves to get some help, but that's not something that the supplier could do. So that means our only choice here really is to petition for bankruptcy. So in Part B, we need to identify whether the statements are true or false. So the first one, when in administration, the creditors of a company cannot take any legal action to recover the debt owed to them whilst the company is in administration. And that's true. So when the person who owes money or the company that owes money is in administration, that means that they're being run effectively by the administrator, and the administrator is trying to set all their affairs in order and try to make sure the company is surviving this sort of issue that they have at the moment with their lack of cash. And the company is protected while they're in administration, so that's true that we cannot take any legal action. Second, the administrator will aim to keep the business running as a going concern whilst options to prevent liquidation are sought. And that's true as well. That's basically the job of the administrator. Let's see if we can turn this business around so that it can pay off its debts. And we're trying to do that instead of liquidating, instead of winding it up. And finally, administration is seen as a less preferable route than the liquidation of company. Well, no, that's not really true, is it? Because we want that company to survive. We want those employees to keep their jobs. We would rather have this business as a going concern so that it can carry on paying us in the future, rather than try to close it down completely. So that is false. Okay, let's move on to the next part then. So a business has been granted a judgment for $6,200 owed by a customer, Mr. Bond, for services provided. Mr. Bond lives in a rented apartment and is currently not employed. He does have investments in a bank deposit account. Identify which of the following would be the most appropriate court order for the business to apply for. So the first choice is a garnishee order, and this is where the court would allow us to be paid directly by somebody else who owes Mr. Bond some money. So instead of Mr. Bond paying us directly, if anybody owes Mr. Bond money, then they would pay us instead of paying Mr. Bond, and that would allow to pay off the debt to us. Then the second choice is a warrant of delivery, and that's where if we've supplied goods to somebody, the courts can insist that they return those goods. But in this case, that's not going to be relevant, is it? Because we've provided services for Mr. Bond, so there's nothing to return. The third is an attachment of earnings. As we discussed just now, this is only relevant for someone who is employed. It tells us that Mr. Bond is currently not employed, so there are no wages that he's receiving, and therefore we can't have anything deducted from those wages. And finally, a charging order, that's where a legal charge is taken out on a property. Like if you have a mortgage, then you typically have a charge on your mortgage. The bank will have that charge and they can ask for that property to be sold and they can take the cash from that. Well, in this case, Mr. Bond lives in rented apartments, so there is no property that could have a charge on it, and therefore there's nothing available to sell to be able to settle the debt. So in this case, a garnishee order would be the most appropriate, so that if anybody owes money to Mr. Bond, then we can get them to pay us directly. In Part D then, we're told a business has a £24,000 debt outstanding on a customer account which they are taking to court. The situation is very simple and the case will be conducted within 1 day. So the county court process which would deal with this size of debt is... Well, we have three choices here: the small claims track, the fast track and multi-track. The small claims track can only be dealt with uncomplicated claims, which this one is, but only for a value under £10,000. So notice in this question they tell us that the amount owed is £24,000, so that's too much to be going through the small claims track. And then if we have a claim between £10,000 and £25,000 that are capable of being dealt with in 1 day, then the fast track would be appropriate. So that seems to be the one that we're going to be using now. But let's remind ourselves of what the multi-track is. So if we have a very complicated case and the amount is less than £25,000 but it needs more than 1 day, then that's where we're going to use the multi-track route. So in this case, the fast track is going to be the correct answer, given the size and lack of complexity in this particular case. Then in Part E, a business is considering including a retention of title clause within its sales contracts. So that means we're going to sell things, but we're going to retain legal ownership of those items until they're paid. So we need to decide whether the goods need to be identifiable to be able to enable a retention of title clause to be used effectively. Well, yes, that's true. If we can't identify those particular goods, then how do we know which ones we still own and which ones we don't? So yes, that's true. Yes, the goods need to be identifiable. Then a retention of title clause will always enable a business to recover its goods if this becomes necessary. Well, no, that's not necessarily true, is it? Because the goods may have already been passed on to somebody else. They may have been damaged. So there are certain circumstances that will prevent us from getting those goods back. Remember, in the exam questions, look out for words like always and never, because that's very absolute, isn't it? And there may be some cases where that may not be true. And then the third one, a retention of title clause does not have to be included in the terms of the contract for it to be used by a business. So this answer is false, because that clause does have to be included in the contract for us to be able to use it and say, look, these goods are still ours, you can't keep them. And then finally, in part F, we need to identify the correct option for each of these statements about insolvency. So the first one, so appointed by a bank under its floating charge and is authorised to sell the secured assets of the company in order to repay the bank borrowing in preference to unsecured creditors. So where we have this floating charge, so this is where we have a charge on an asset. So we're saying that we have an interest in a particular asset, but because it's a floating charge, it means that the assets could be moving. We'd have a fixed charge on, say, a house, let's say that'll be your mortgage, but a floating charge maybe on things like inventory. And so if we're going to appoint someone to take control of these assets so that we can get our money back, well, that's going to be a receivership. Receivership is the process where we can try to enforce the security against the assets of whoever owes us money. The next one then, so someone appointed by the court in the situation where a company is having solvency problems, and it is considered that the insolvency practitioner appointed has a reasonable chance of being able to rescue the company rather than wind it up. So we talked about that earlier, didn't we? So that's going to be administration. The point of administration is to try to protect the company and keep it going. And then finally, a procedure in which a company is brought to an end with all of its assets disposed and the proceeds used to repay its creditors. And if there's any money left over, that can go back to the owner. So that's the idea of liquidation. So liquidation is where we're winding up the company.